Okay with me too.
We need to
Our side.
we are live. Welcome everybody. It is Thursday, April 23rd, and we are turning our we're pivoting again. Well, actually, we're just continuing on some consumer protection work that we have in front of us. And this morning we're going to be looking at our news bill and at our genetic data privacy bill, and with the hope of getting them both out fairly soon. And we're lucky enough this morning to begin with the original sponsor of the bill, who is also our chair of House Appropriations, Robin Shy. So, Robin Shy, introduce yourself. It's wonderful to have you. I think you know us all.
Do
you know David?
I know who you are.
Rutland.
I don't know if I like that.
And Randy, I know.
You know Randy, me,
I know you.
and Keisha. Yeah, because people may not have had the opportunity to have the pleasure of working with you.
Yes. Well, Robin Shy, Representative Robin Shy from Middlebury, also chair of House Appropriations. I'm not here in that capacity. I'm here as a representative.
Right.
Bill, I rarely do bills. I've done 2 or 3 in my 10 years here, so I'm not a do a bill for everything person. But this bill related to genetic data privacy, H639, I got interested in because of my own personal interest. I on a whim did Ancestry. I wanted to see how much Norwegian blood I had because my mother's Norwegian and my grandfather's like about. And I got the shock of my life when I found out that I was donor conceived at the age of 66, and my father's not my father. Yeah, it's a real shock to find that out.
And
Your parents were both gone.
Wow.
Yeah, but I found 3 new bonus sisters and a bonus half brother. And my sister has a different father, and it's quite astonishing. Whoever thought, you say you hear those stories. Well, I'm that story, which is, it's been quite extraordinary to live with this and to have your life changed as an older adult of what you thought. So anyway, genetic data is very interesting to me. And then, so I did that through 23andMe, and then I also did, Ancestry, and then I did 23andMe, and then about a year or 2, I can't remember, I'm sure time,
For a year.
year and a half, 23andMe started having trouble and went bankrupt and ultimately got sold to a third party. And I knew what I was getting into when I signed up, more or less, but then another party gets in and you don't know what's going to happen. And I'm fine and I'm in good health, but I worry about what could happen with other people who are maybe not. So at the heart, this is a consumer protection bill, as you've already heard, and it's really designed for a couple of things: to make information much more easily understandable to consumers who give their DNA to these genetic data, consumer direct genetic data testing companies, whatever they're called, direct to consumer, so that Vermonters really know what they're getting into. And right now, it's sort of like when you agree to updates and there's pages on your computer and you just scroll to the bottom and see agree. So the idea is to have separate and express consent for each of a number of different things, as opposed to one big thing. So you can just choose consent to A, but not to B, or all of them, but you have to do them each at a time. So that's one of the things that this does. It also, and it also makes it easier to revoke consent if you change your mind 6 months later, or they're starting to sell to another company, whatever you want to get out there. It also ensures that data won't be misused and that they can't sell it to insurance companies and give that your genetic data information for healthcare or long-term care insurance or any of those kinds of things. And so you can't use this to deny somebody their ability to get health information. And if you have a family history, I have a friend who has a family history, although they individually do not, for ALS.
Yes.
And if they were asked by the insurance company for, before they could get health insurance, imagine what that would do. And that would ultimately do the healthcare system, never mind the individual who would have a real trouble.
I think the things that we haven't yet fully determined are genetically inherent.
Right.
That people think of or have a prejudice
Right.
that may be at the time.
Right. So
And now.
protecting folks that way, and again, when 23andMe was sold, went bankrupt, you know what you got into with the first company, but you don't always know what with the second company. And so there's protections around that. And ironically, the day before I was testifying on this in House Commerce and Economic Development, this article came out of the New York Times, which I'll send to your
We'd
committee
love to have
assistant.
that.
Genetic data from over 20,000 US children misused for race science. The National Institutes of Health failed to protect brain scans from an international group of fringe researchers who use their DNA to argue for the intellectual superiority of white people. So the stuff happens,
So yeah,
you know. So that's why it's important to me.
got it. I appreciate that. So having thought you were also Norwegian,
I am Norwegian. Actually, my mother is my mother.
so your mother is your mother.
Yes, and I'm
And she
Norwegian.
is the one who was Norwegian.
Yes. Yes. And the father who raised me was Scottish and English, and my biological father is also Scottish and English. So I didn't notice anything until names started showing up saying, these people might be your relatives, and I never heard of them before. And then they reached out to me. And I've now met my three sisters. Everybody was born in the same area. The father was they used to use residents, medical school residents. And so Cornell Medical School in New York City.
Donors, you mean?
Yeah,
Huh.
as sperm donors. And they would get paid for that. So we all shared the same father and all different mothers, and all were born in the New York, New Jersey area. Most everybody still lives, in New England. So
Wow.
we have Zooms every month. I have a new family. I mean, that's the good side of what happened, but there's still this other side of, wow, my family's, it's,
Well, they're still your family.
they're still my family. Yes.
Yeah.
But it just puts a whole different frame on your life, which is quite shocking.
Well, and it does remind us how important for many of us. Family of nurture is critically important because they're the two people who invest time and energy in you and cash.
Yeah.
But family of blood is also just so deeply.
Yeah. Not to mention the health stuff you'd like to know, right? Because you think you know what the health background is,
Well, as we age, that seems to be more important.
Keep moving.
Any questions for Robin before we move on? No. Great.
Okay.
Thank you. Thank you
You're
for
welcome.
putting this bill forward. Thank you for sharing your story with us.
Yeah.
And
Thanks.
good luck in conference.
Thank you. And I've worked with the Attorney General's office and like to thank also helped me out tremendously in addition to legislative council.
Right.
Yeah.
Terrific.
All right.
Thank you very much. I think we may want to wait and do the new draft a little later. So I think before we do the new draft, let's chat with Richie, who's come back to us. Richard, are you wanting to go?
No, Master.
Because my understanding was you didn't want to testify.
I think
but-
he's gonna cover most of it. Thank
Although
you.
we always welcome if you'd like.
Thank
to.
you. I appreciate that.
Yeah, thank you. Richie, welcome back.
Thank you. I've been to Vermont more than any other state than my own this year.
And remind us where you are anchored.
I am anchored in Chicago, Illinois. So very nice, easy direct flight.
And a wonderful city. One of the best designed cities in America.
Easily the prettiest big city. I think.
It's a wonderful big city.
Yeah.
With some of the greatest architecture.
Yeah.
Next to Buffalo, of course.
Are you joining us for NCSL this year?
I never go to NCSL. It's too big a conference for me. But my colleagues may be at NCSL this year.
I tend to agree with that, by the way.
I do CSG, just Council of State Governments, because it's, I love the CSG East, the ERC, Eastern Regional Conference, because it includes our 5 Eastern provinces in Canada, our biggest trade partners.
Yeah.
So for me, as the Vermont senator, it makes more sense for my time to spend time in an arena where we're actually playing and working and.
Yeah, and I think the CSG meeting, or not CSG, the NCSL meeting in Boston last year had 12,000.
No, it's just a zoo. I mean, NCSL is an incredible resource for us, but those conferences are huge.
Yeah.
Richie, welcome back.
Thank you. So Rich Engelhardt, Head of Government Affairs at Ancestry. Happy to be back to continue the discussion on the proposed genetic privacy bill. And I just first want to thank the committee for involving us in the process as we've gone along, as well as Todd at the AG's office. I think you're everybody's best friend from this chair right now. We have some technical nits around definitions of biometric data and biological samples, and I think we made progress on that.
Yep, and we'll see
in the new draft.
in the new draft.
So as we've said all along, we remain committed to the policy sections of House Bill 639. They reflect the industry standards that we set and then supported codifying in 15 states over the past 6 years. We're also still very strongly opposed to the private right of action. Our chief privacy officer detailed that earlier this month, the PRAs encourage defensive postures, even in the best meaning companies, delay privacy remedies and add cost to consumers. In the past 2 decades, the direct consumer genetic tests have been available on the market. Illinois had the Genetic Privacy Act of the PRA, and it provides a stark example of why it's a terrible idea. Sequencing.com settled a class action lawsuit that alleged their use of a third-party developer for their own website constituted improper sharing of genetic data. Ancestry and our private equity owners were sued and prevailed against frivolous claims. Not once has a DTC company been brought to task for an actual privacy harm where the plaintiffs prevailed in Illinois. In fact, the most high-profile settlements in Illinois under their HIPAA have ended up being against companies with a large presence in the state. Ford, United Airlines, Union Pacific, and even the gas company. All for technical violations the legislature likely did not have in mind when they drafted the statute. When large penalties are at play, such as the statutory penalties in Illinois or damages for actual injury in the bill before us, that can include emotional distress and other non-economic damages, there's a strong incentive for professional litigants to pursue any case, whether an actual privacy harm has occurred or not. This introduces a lot of uncertainty and unknowns for companies operating in the state. First, actual damages can include non-economic harms, such as emotional damages. It's difficult to know how a judge or a jury would value the potential anguish of genetic exposure. There's also a provision for treble damages under the Consumer Protection Act in Vermont, which could ostensibly lead to damages in Vermont far outpacing other states with similar genetic privacy statutes. And without a meaningful right to cure, companies like ours could be stuck in discovery for years like we were in Illinois with no offering. In the last hearing, we were asked about a potential right to cure provision. And while we strongly prefer that the bill not contain a PRA, other states have successfully modeled how right to cure provisions can lead to remediation before the courts are involved. Early on, Virginia provided a 30-day right to cure on their privacy bill. Since then, the standard has expanded to 60 days, with states like Kentucky, Connecticut, and Maryland incorporating right to cures into their statutes over the last couple of years.
Can I ask you a question on that?
Yeah.
Sorry to interrupt. Those right to cure is applicable to biometric data or broadly to rights to cure
They're-
privacy?
They apply to everything in their omnibus consumer privacy acts. And all of those states address biometric and genetic data in their consumer privacy statutes. The states with 60-day timeframes justify the longer period because technical remediation for complex forms of data require full engineering sprints that simply cannot be completed in a few weeks. The Connecticut AG's own report on their right to cure shows that the 60-day window allows for the successful resolution of most violations before they hit the courts. And aside from Illinois, Wyoming is the only state that allows a PRA on an expansive genetic privacy statute like the one before you. And that state allows for a 60-day right to cure. And we've not experienced the same legal mischief in Wyoming as a result. There are
Wyoming adopted a cure period.
Yes. And actually,
60 days, right?
it's 60 days. And the language from Wyoming is it's almost word for word what we submitted to the committee in our written testimony. There are countless technical violations that are easily curable under a genetic privacy statute. If an individual's data is inadvertently included in a research data set, it can be pulled back or the consumer can choose to provide the appropriate consent. Data can be pulled back from third-party vendors if the consumer disputes that they meet the service provider definition. These are just two of many examples. We provided the House Committee with a potential right to cure provision and have shared that today in our written comments as well. If the committee decides to move the bill with a PRA, we hope you'll seriously consider incorporating meaningful cure language. We take the privacy promises we make to our consumers seriously. It's why we were at the table before any legislative body asked us to promulgate the best practices that this bill is based on. We remain concerned that punitive enforcements like the one in H 639 will provide a strong disincentive for companies like ours to self-regulate in the future. And we would continue to ask the committee to consider the most effective way to provide protections for Vermont consumers that don't bring unnecessary costs to companies like ours that invest heavily in the state through public-private partnerships. And with that, I'm happy to take any questions.
Are there questions?
Eddie, does any other state have a private right of action? I don't know if you may mention that in your opening, maybe you didn't understand.
So Illinois has a genetic privacy statute with a PRA. That was actually a legacy bill in Illinois. So their biometric and genetic privacy laws were passed in 2008.
Yeah, we chatted about it fairly extensively yesterday. It's quite different from us because they have this, you know, it's
The damages are spelled out, but they've had to change so much
They
about
have
their
this-
law because it's so
Right.
much damage to.
but there are other states. There's Wyoming and there's also Arizona.
And they have right.
Arizona doesn't have a PRA.
I believe it does.
No,
New Mexico.
I don't believe New Mexico has not run this bill.
I believe our legislative council
Yeah.
feel it's different.
I'm happy to review that, but
Yeah, New Mexico, sorry.
I've been in all 15 states that have passed a version of this over the
New
last 6
Mexico,
years.
Well,
Yeah,
it appears
hearings about PRAs, at least here in Vermont, some have claimed that the PRA is almost the only remedy that is available because the state doesn't seem to have the remedy or the energy to actually have the AG's office to take it over.
or the
Or handle it.
capacity. I mean,
Or the capacity.
let's be
And, you know, how would you respond to that kind of situation?
Yeah, I mean, well, if you looked at what happened at 23andMe last year, the AG's office in Vermont did get involved, right? And the privacy
But they
violations.
weren't the leads on it. I mean, they
No,
were part
well-
of a much bigger action.
And I agree. And, you know, when the AGs band together, nobody's asking Vermont with more limited resources to carry as much weight as a Connecticut or a California, which were the two states that co-led that investigation. They can all band together on behalf of their citizens, which is what we saw happen last year in the wake of the 23andMe bankruptcy.
Well, that was a huge issue, though,
Mhm.
that involved thousands of people. And the kind of issue that might involve in Vermont might involve one person, it might involve 10 people. And the question is, would the state have either the ability or the energy or the desire to take legal action, whereas an individual with a PRA could?
And I can't imagine a privacy harm with a company that has a genetic database like ours that didn't involve the entire database, right? Nobody's like, oh, you know, don't really like Allison's green today. It doesn't match my green, so I'm going to improperly share her genetic data. We're just not seeing that happen, right? It's things that happen with the entire database, the company's entire privacy
Based on
policy.
your experience elsewhere, where there is no private right of action, do you find state governments doing anything about violation or problems?
Well, again, 23andMe is the piece that we keep going back to because the other thing about this industry is it's been remarkably well behaved. And 23andMe, if you look at what happened in their bankruptcy, you know, just to clarify something that the first witness, the author of the bill brought up, 23andMe actually didn't get sold to a completely different entity. The founder formed a nonprofit and bought the company out of bankruptcy. She changed the financial structure. It was a private company that was taken, or a public company that was taken private. And the only reason they ended up in bankruptcy is she couldn't come to that agreement with her board ahead of time. So she kind of forced the company into bankruptcy so she could buy it out of bankruptcy and form that nonprofit. Same leadership team, same privacy policy, same privacy statement, same terms, same basic, you know, concept. Nothing changed before and after that bankruptcy, except the fact that it was no longer a public company and was held in a nonprofit.
Except that millions of people were terrified about what it might happen to your data if it was.
Because
Right.
I do, so the AG's office has a consumer protection hotline that is run through UVM students and overseen by an attorney. I don't know, Todd, and that receives complaints. I have said before on the record that I have been made aware of companies that have first received a letter from the AG's office saying, we're going to, you know, we want to issue this large penalty. Certainly it doesn't become that by the end of the court process. But that was based on some complaints to the consumer protection hotline. I think it was way outsized in this case for the complaints that were submitted through the hotline. But I haven't seen any reason to believe that if the AG's office thinks there's something there, a pattern that they find through this hotline, they do communicate with the company. How they communicate and whether or not it's particularly well founded, I think is an open question, but I want to answer your question as correctly as possible. We have a system where people can make complaints.
Well, that in a way is my question. I'm not a fan of private rights of action.
Yes.
As you may know, in the least. But what I am interested in knowing
Yeah.
whether or not the alternative of not having that is working in other states. Is
Well,
it effectively
that's a good
protecting
question.
privacy rights? Is it effectively going after egregious violations?
And I remind us that this is a very, and we have Todd here to discuss this, but this bill is a very narrow private right of action. This is not as broad as the privacy bill or others. So I would also love to discuss that because
I don't know, what do you mean by narrow?
we will have Todd discuss it and explain it.
Well,
And Rick, because we have our two legal experts here, but
yeah, and just to address the gentleman's comments about how consumers can seek redress. The Illinois GIP has been on the books since 2008. That's the same year that 23andMe went to market with the first direct-to-consumer genetic test. So we have about 18 years of experience here. We've never seen an individual sue under Illinois GIPA saying that, you used my data incorrectly, I suffered a privacy harm and for that. We've seen a lot of frivolous claims against a lot of companies. That list that I gave you, those aren't companies you would necessarily think, like,
Right.
how is there even a genetic privacy harm?
And them having to field those is still expensive. I mean, that's the thing.
it's
Like,
expensive to the state too. I mean,
that's
it's
what I'm
expensive.
saying. So
So,
we're
I
saying that the AG's office doesn't have enough capacity, but you might be suing a school district, a hospital,
That exists now as our
a company,
already. in-
and
right.
they have that costs the consumer more when those cases have to be dealt with.
My question for you is, if no private right of actions have been filed in Illinois, what are you so afraid of?
Well, we've had the frivolous claims filed in Illinois that we've had to spend
They could have been
years.
filed anyway, right? They weren't filed under the PRA.
Oh, no, they were.
Oh, okay.
Absolutely. Right. So
And we have had very few, I mean, just so you know, in Vermont, we have a private right of action in our consumer protection statutes, used very rarely. I mean, Todd can speak to this, but my understanding is they're used almost, just very, very rarely. Tom,
Two questions. One, for the 15 states that do have a PRA, I understand Chicago has a financial penalty. Are the rest all injunctive relief only, and does this bill only allow?
So the other 15 states don't have a PRA, they're AG enforcement.
Okay.
They have statutory damages that the AG or city, various different people aside from the AG can prosecute as well. If you look at the California statute. So like the city prosecutor in a city of a certain size, certain DAs are authorized to bring cases. So all the workload doesn't fall expressly to the AG's office in the California statute. But it's statutory penalties that have to be brought by an agent of the state.
So the other states that have similar legislation do not have PRAs, but for Chicago or
Illinois.
they're all AG.
Second question.
Yeah.
Can you elaborate on the cure period, and in the circumstance if we did add a cure period, how would your organization resolve? What are some examples of things that you've done in the cure period to avoid the illegal contact?
Well, and
And then there's only Wyoming with a cure period, there's
correct.
only one state with
Correct.
this.
Wyoming's the only state that's attached a PRA to this model of bill. And they added a cure period to it. And I might just be thumping my chest a little bit on my company, but we have not had privacy claims brought against us because we by and large do the right thing. The standards in this bill are the standards we've had in place from the word go. So when we pulled in Consumer Reports, medical ethicist, the FTC, Future Privacy Forum to promulgate best practices that this bill was ultimately modeled after, we were looking at what we were already doing, right? And I think a big part of that is Ancestry, 23andMe, MyHeritage, the big three. If people don't trust that we're guarding their genetic data, they're not going to use us, right? You saw what happened with 23andMe after they had their data breach in 2023. And that wasn't even a situation where the company systems were compromised. It was a credential stuffing attack. So other data breaches led to everybody's login credentials being available on the dark web. They took those login credentials and walked right in the front door because they had the username and password of millions of 23andMe users. It's still a data breach, even though 23andMe asserted it was not. But the loss of consumer trust from that incident alone, they lost over a third of the people who were in their genetic database because they didn't trust them anymore.
Right.
right?
We haven't even talked about, what is it called? Like, the Butterfly Project, or there's a form of AI that is getting so powerfully good that it essentially could break the internet. I mean, it can hack anything. It is,
I hope you're not relying on me to solve that problem.
no, but I am saying, like,
But in front of us now is actually considering a cure period. So I would like to know, once genetic data has been breached and it's out there, I don't know what I'm sure happens. I mean, for me, that's the challenge with it.
So most
Cure period is like, but thinking about this, it's
that's exactly what
all of the sharing that
it's very hard.
That's hard.
You
so
can
it's
hold
reason.
someone responsible, but this is going to keep happening and keep getting better with the way AI
Yeah.
is going.
But with companies like ours, the legitimate business cases where we share genetic information, we do with consent, right? So if you are included in a research data set and you get a notice saying, hey, thanks for joining the research project, blah, 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 blah. Right. Wait a minute, I didn't sign up for that. It was inadvertent on our part. We can call that research partner and say, hey, we need that genetic profile back. We need it to not be included in
So
the data.
that
So
goes.
the cure period.
Right.
Okay.
Instead of having someone say, oh, they made a mistake, let's run off to court and sue.
No, I appreciate the value of the cure period. It's not what I'm concerned about. I mean, just with genetic data. I mean, yes, if it's going to research project, that's fine. I mean, it may or may not be fine, but it's not immediately compromised in terms of who you are, how it might be used. If
Right.
it's taken by a more nefarious actor, it could be far more damaging.
Yeah, and that's
And
more likely going to happen
Claw
with the
back.
concept of a breach than
Yeah.
the company actually saying, oh, we're going to hand this over to somebody who shouldn't have it for.
Right, exactly. So I guess
purposes.
that's my question is, once that's happened, for me, it's a little harder. I mean, the research data makes sense. I mean, you could claw that back in a cure period. But the other stuff, much harder to claw back during a cure period.
Right, and like I said, if it's going to a nefarious actor, that's probably like in the case of 23andMe as a result of the breach. And one of the things I'm quite proud of this company is that we don't look at every bill and say there should be a PRA, right? For data breach, it's obvious, right? If a company suffers a data breach and they do not do the things that they are statutorily required to do, it's obvious. We've supported adding genetic data to data breach statutes that have a PRA.
Right. But
Right.
isn't that, and we're gonna have Todd speak next, and then we can discuss this. But my understanding from Rick and from Todd is that this is very narrowly designed to be very narrow and address
Yeah.
exactly what you're
What do you
looking
mean by
at,
that?
and that we're gonna have. So
But
we,
you, like, what are you
My-
saying is narrow? How do you define narrow?
I don't know. That's what I'm gonna ask Todd and Rick about. So, Richie, could we just switch places and
Yeah.
Todd, because we can continue the dialogue.
Yeah.
But I just hope to hear from Todd, because we talked about, I mean, in the first talk,
I'm
a
not
narrow,
going too
a
far, so I
narrow,
could jump
a
back
narrow
in.
PRA. So I'd love to at least appreciate what that is. And how narrow is it, and why is it so narrow? Can't answer free, live with that. I mean, so that's, I guess, my question.
Certainly. Good morning, Todd Balo,
Long time no see.
Assistant Attorney General. Thank you. It's good to be back. Great conversation, and appreciate Richie as always, sort of the perspective from industry on this. I'll start with a very simple statement. Nobody likes being sued. And at the end of the day, that is what this conversation around private rights of action is about, right? It's about companies attempting to protect themselves from litigation across the board, whether it is frivolous or meritorious. Stepping back to my old role, when I first worked at the AG's office, I defended the state of Vermont. And I defended whether it be troopers, commissioners, or departments or statutes. And I will tell you from my perspective as a defense attorney, so the same kind of work that Richie's attorneys do, there were plenty of complaints I got that I would have determined or characterized as frivolous. But I will tell you, the plaintiff on the other side did not view those cases as frivolous. That's a pretty natural posture for attorneys to take, for businesses or entities like the state to take, is that we don't think we did anything wrong here, but that's what the judicial process did. That's kind of my framing overall. coming back to a PRA in the consumer context, we've had a private right of action in Vermont for over 60 years. Sorry, not quite 60 years, 1967. That's bad math. Or I'm just getting math. Almost.
A long time.
A long time. We do not see, and we have not seen, the kind of excessive litigation that we hear about in a lot of these conversations, largely from tech companies, who are concerned about private rights of action. Illinois is an example of a challenging private right of action for industry, understandably. It incentivized in a certain way more litigation than other industry had seen. And part of the reason it did that is in attempting to determine what the value of data is. The Illinois legislature said, we're not gonna have it get figured out on a case by case basis. We're gonna say any violation is a statutory set of damages. Well, that means if you're an enterprising attorney and you're looking for business, you find a big enough violation of the law. Each one of the people you get to sign on equals X dollars. And that motivates a lot of action. I won't weigh in on whether cases are frivolous or meritorious. It's good when the process plays out, companies are able to either settle a case appropriately or vindicate their position. But I will say about genetic data and why Vermont's law is different is twofold, if I can do it. One, there aren't statutory damages here. There are not. In Vermont, 9 VSA 2461B, which is the private right of action, allows a consumer to seek damages for the actual cost. So maybe that's your subscription to Ancestry.com, or maybe in the worst case scenario where your data gets out there and somehow you're maligned or attacked, or let's move it out of the that world, but other data breaches, people learn where you live and can access your home or otherwise. There may be greater damages that come that, again, we've got a legal system for this, are caused by that initial violation of the law. What there isn't is a set cost for any I not dotted or T not cost, which is the argument against the Illinois. And I think what we are doing and have advocated for across the board in a lot of these consumer protection measures is continuing with Vermont's well-trodden path to allow consumers to vindicate themselves. The only other point, I think this gets to what you were saying, Senator Broad, when it lands on the AG, and there are other instances in Vermont law where the AG has the enforcement authority. So we are asking taxpayers to fund litigation. And we, as the AG's office, can't represent Randy Brock. We can represent Senator Brock, but we can't represent Randy Brock, the consumer. And if we represented the entire committee, because as Rich pointed out, some of these violations are likely, if they were to happen, maybe not the industry, but another actor, likely it would impact a whole bunch of people. Maybe the AG could take action in that place where there is a harm to the state and there's a pattern of practice that we could suggest was harm to the state. But even in those cases, there's no recovery directly, or it's very unlikely there'd be recovery for the individual consumer. That's what private right of action does. It also allows those actors, those individuals, to again vindicate their own rights, have their own agency, have their own ability. And in a case like this, where one, we don't see a lot of these cases, right? I mean, as you heard Richie say, Ancestry hasn't seen any in Wyoming where there is a PRA, and I believe very few instances where people have even used the cure period. So the last thing I want to say before I get to those questions is we don't have any other cure periods for law. Not in the consumer space that I'm aware of. This would be the first. And I think, as the chair stated, the danger period is you can't cure your genetic data being out of the world, right? And maybe, as Senator Ron Pinsdale said, it's going to be challenging to figure out what the overall damages are, but I think that's something that a court process can work out. But what we can't do is put that toothpaste back in the tube once it's out. And that's why maybe there are other places, I can imagine in other data privacy spaces, some kind of cure period where there's something.
It makes sense for some other things, but I'm just, it's more concerning with genetic data.
So I'll stop there.
But can I just finish while you're there before Thomas asks this question? Because so many people have said, to me, and that this is that this bill has a very narrow definition of the PRA, or that the PRA is very narrow. What does that mean? Because I know that I've heard that, but I don't know what it means. Does it mean it's very specific? Does it mean it's
It is, it
What
is
does
the
it
same, so great question. It is, the same PRA. It's 2461B that exists across the board, but it only applies to violations of this chapter, this, well, I guess, is it gonna be a subchapter in the end? It's a little joke.
yes, right?
Uh,
It's only applies to this chapter.
And so,
It only applies to genetic data.
and it only applies to, it really is regulating the direct consumer. It's not, if you fall into the category that is a direct to consumer, the definitions, on page 2 of the bill.
But you gave us an example of where that could happen. That was a situation of the genetic data being released to a research institution and being able to call it back. And so it sure was possible.
Yes, that's one instance of it, but
May
if
not,
it's,
obviously, if you have the broad release by a dishonest group.
So let me throw this, using that example, this is a good example. What is the damage done to the consumer in that instance?
You don't know.
I think it'd be really hard to prove harm.
Yeah.
And so it'd be really hard to even state damages in a complaint and get that complaint to go.
agreed.
So I don't know that the cure really moves the needle on that. And the issue from my perspective is, so one example is this bill does a great job laying out express consent across the board. If some of that consent,
And this company sounds like it has
absolutely,
designed it very well so that you go stage by stage by consent by consent. We wish everybody did the same. I mean, just designed it as simply as that.
hand in glove, right? I mean, this is, as Richie said in his original testimony, a lot of this bill is based on what Ancestry has offered and suggested and their practices. And we think that's a great way to do it. But if there was something wrong with that consent form and the consumer, for a technological reason, a lack of express clarity within the language, consented to the transfer of their data for whatever reason, arguably that's a technical error. We can cure, right? Give them 30 days, 15 days to cure. Should be easy. Problem is, once you've checked the consent box, legally, that company
Right.
can transfer that data based on the
So
consent.
you can't cure something that you actually did.
Arguably. And so that's the challenge with it. Is, and that's why we
Say, I
think,
didn't mean to.
Yeah.
Or I was under the influence, or
and again,
someone forced me.
so latter one, I think would be a much harder case. But really it's technical error and it creates an uncurable problem. And that's why we're suggesting no cure period here. And as I said, it would be the first.
Well, I'm really glad you raised that because I was going to raise the same thing. I just don't see what the harm of still giving them that flexibility to resolve the concern or complaint during a period of time to avoid the litigation. So what is the harm of offering the cure period? In both circumstances, the data will be disclosed. In both circumstances, just one, you have to go straight to court. The other one, the company can resolve it during a period of time with maybe avoiding additional litigation. I don't see the harm of giving them that cure period option.
So again, if the transfer has occurred and the data's out there,
Yeah.
there's no cure.
In both circumstances, with or without a cure period.
So your suggestion is if they can't cure it,
They might be able to satisfy through other means, as the example was given, that they could ask for the person to give it back and then delete it, which might be the end result anyway.
But if it's already gone, it's gone.
But it'll be gone in either circumstance.
yeah, I think there are a couple pieces there. I think there's an equitable piece about just access to justice in that, right? And that, again, we could be delaying any amount of recovery that, and I don't mean financial recovery, I just mean remedy. And two, I just question why this industry should be treated differently than all the other industries.
So I had two other points. So your 1967, would you agree that that was the automobile age and we are now in the information age with a knowledge-based economy and that this data privacy is a different animal than it was 60 years ago when we passed our Consumer Protection Act?
I think a lot of consumer law is both fundamentally the same. The majority of our complaints are still automobile based. And we've got a tool that has worked over those 60 years, and nothing in Vermont's experience. Setting Illinois to one side, nothing in Vermont's experience suggests the system's not working, has to continue to work in the information.
That's the PRA from the testimony yesterday, to see non-liquidatable damages with unclear involved partners as a reason why we shouldn't involve a PRA and we should have this go through government. Because in that circumstance here, what you made the point, what are the damages? How is that person hurt? It's hard to define that. So to have those nuisance lawsuits, which can negotiate for settlements, is a concern for me, especially when I'm understanding now that only one other state does have this PRA for this thing.
So I'm not sure the state has any role, right? Again,
Because it's such a, because genetic data is so individualized.
well, I think that, and if we place all the burden of work on a state entity, right? So whether it's lead paint complaints or automobile complaints or genetic data, we're still pushing all of that through a taxpayer-funded system.
But I don't think they're comparable. I see those as having clear, defined, involved parties with discernible damages, whereas this seems to be the opposite from the testimony yesterday, and even to your point just now, the damages are unclear. It's hard to quantify what the actual harm, the financial harm is, and sometimes the involved parties, because the data is circulating through a variety of sources.
So here, direct consumer companies are it. Data brokers is a much broader field and a much broader definition that's going to incorporate tons of different business entities. That is not the case here. As Richie testified, there are really 3 companies that occupy the majority of the space. There may be some smaller actors, and frankly, those are the folks who'd be most concerned about, because I don't think they have the reputation and the integrity to follow best practices at the law. To your point about unrecoverable damages, I think it actually cuts the other way. In Vermont, you're not going to get an attorney who's going to take that case. There's no recovery, so there's no ability to pay the attorney. There's no, the nuisance lawsuit, right? That idea of a Dunning letter, a letter that goes out. We used to have to patent trolls, right? People happened with, in a similar circumstance, but it got more press. The Eat More Kale, right? There was a push around Eat More Kale being attacked by some company that had a chicken,
Yeah,
right?
the chicken.
So we get those cases, those exist across the board in lots of different contexts. But if there's no money there, you're not going to see this plaintiff's bar come into it. And that's where the Illinois case is an outlier versus Vermont, right? Where in Vermont,
Because they have damages embedded in their statutes.
yeah. So if you can demonstrate somehow that the release of your information without your consent to a research company that then was able to ship it back with no public disclosure, I don't know what your damages are, and therefore I don't know what you get out of that litigation except paying an attorney to carry that case to a very low dollar or no dollar recovery.
Yeah.
So, but you'd be doing away with the private right of action for all of the cases. And that's where I think the crux lies, is that this committee has talked a lot about private rights of action. I think it's a very healthy conversation. And we're also talking about it in the abstract, based on other states and other laws, experiences, not based on Vermont experience. I think the chair said, and I don't have the exact number, but we file consumer complaints and consumer actions, but by and large, they're against national corporations that are, in our view, engaging in unfair and deceptive acts and practices. We do some of that work, as Senator Ron Hinsdale said, through the CAP program. Largely, that's a mediated process. We don't see a lot of these cases, and we don't have a number, because no one has to report to us all the 9 DSA cases that get filed by the private party. But we're not aware of them overwhelming the courts or really straining the courts in the current moment. And I would say it's very unlikely that this bill will move the needle on that, especially given how reputable the bulk of the actors in this space are.
Right. So when you talk about Thomas harm, there are, with genetic data, there are real harms that could be caused and felt by an individual. The research thing is an easy one, but your actual genetic composition let breach to an insurance company that's deciding whether or not to cover you, or a hospital who is making decisions about how they're going to treat you, or it strikes me that there are a lot of ways it could be used that hurt the individual in a way that, and do hurt the individual conceivably. I mean, luckily this has not happened, it sounds like, very often. So, but in those cases, our consumers, our individuals, unlike some of the broader cases and data brokers, this is direct to consumer. The direct Vermont constituent we have is affected directly by a company. And so in that case, it makes some sense for an individual to be able to take recourse on their own without having to use a state actor to protect them, because that will be a much broader piece. It may only be an individual who's affected on this. I mean, is that accurate?
Yeah, I mean, again, it's all hypothetical, but I think your point about the difference between data brokers and this is there is a consumer relationship here.
Yeah, this is a
You're walking
direct
in the front door, you're
consumer.
paying. Data brokers, you don't know who owns your data. You don't know what they're doing with it. You don't know how that information is flowing based on the various inputs into that broader data. So I would put that into a different space than this.
Yeah. So, you know,
And to your point about narrowness, again, we're looking at a small direct industry, and part of the reason AJ is pushing for this and why I'm sort of, dumbing down ERA or protecting it in this instance is the most fundamental data we've got.
Right.
And
ourselves,
it's immune, right? You can get a new social security number, change your address.
but you can't get new genetic data.
Not yet.
Genetic
Not
composition.
yet.
Not yet.
Yeah,
That's a
not
different bill.
Word. The
So-
phrase is not yet. I would certainly envision the possibility of a company developing technology that by looking at your eyes from a distance with camera, I can tell whether or not you have cancer, whether or not you're going to get this, that, or the other. I can envision that even.
So I think, Rick,
And so the question is, do you provide any protections for situations like that? And what's the best way to do that, if any?
More than happy to talk about
and,
how
and
biometrics are used, the data, but that's not this bill.
that's not this bill. This is biological, genetic.
We agree that data breaches can happen with or without a PRA. They're likely to happen with or without a PRA. So in your mind, the PRA is just so that consumers can file more lawsuits if they feel harmed when these data breaches occur.
I would say.
File
that
a lawsuit.
A lawsuit if they are. I mean, again, I don't think, based on our experience, and we may come back if the courts get overwhelmed, but we haven't seen that. And we've had these PRAs again for generations.
And this is different from, I think, our other bills, and that this is direct to consumer. This is a consumer's genetic data.
It's a little bit more like buying rather than the information, right? Because you are making that, you're having that direct relationship.
Right. Rick, would you
Versus data
come and join us and just talk about the changes that we've made? So,
Madam Chair, can I respond to
sure.
some of what you said? Because if I heard you right, you just said we need a PRA so Vermont consumers can seek redress in courts, and no attorney in their right mind would take the case, which seems to be a little contradictory.
I don't think you said that, Todd.
He did say no attorney would take that case because there's no damages to recover, right? And what we're concerned about are the emotional damages, which have not been tested in courts, have not been defined, and Vermont has treble damages for exemplary damages. So if a judge says it's $1,700 in emotional damage, congratulations, you now have higher statutory damages than any other state. And that is going to be absolutely a carrot for trial attorneys to come after us, to try and get settlements, to try and take cases to court. So it's not the case that consumers currently have no redress. Because as you also noted, they are in a contract with us, right? They spit in a tube, they agree to our terms, we get separate express consents, that creates a tort, right? If we violate the contract we have with the consumer, they can seek redress for same as any contract being violated. So that is where we were really nervous that this emotional damages has not been tested. So what is the value of someone's DNA being leaked? We don't know how a judge or a jury would see that in Vermont. And the EGO's office doesn't either.
And it's a fair point. Also unaware of any consumer cases that have provided treble damages for emotional harms.
Yeah,
Not
it
aware
doesn't
of it.
strike me
And
as an emotional harm issue. This strikes me as you could have direct financial impact and health impact by your data being
And,
breached
and
in.
if I can say,
Well, and to that point, that's illegal under federal law. So the Genetic Information Non-Disclosure Act, you cannot use genetic information for any health insurance discrimination provisions.
That's all
How
right.
you provide it. Yeah, that's already accounted for. Go ahead.
yeah,
I interrupted you.
no,
Okay,
I appreciate it. And I don't want to have a total tit for tat because I know that's not helpful.
Yeah, yeah.
And that's not actually how,
no, no,
I would just say you can make the same argument for any consumer harm, right? That provision of exemplary triple damages, again, has existed in law for a long time. I'm not sure it was in the original Consumer Protection Act, but I believe it's been there for a long time.
is it exemplary treble?
So you can get
What's
exemplary,
Second word,
you can get exemplary damages at triple what you demonstrate. But again, we've never seen that in a lemon law, a lemon case for an automobile.
we
some-
haven't seen that in Vermont.
Yeah, and so it's true, and I guess I would just pitch one philosophical Democratic point. If a Vermont jury reaches the point of a verdict where they find that an individual has suffered such harm that they believe triple damages, the only way to demonstrate to that company how bad their action was, that's how democracy works. That's what a jury is. It's a democratic form of determining justice. And so I would say if it ever got there, that's how it happens.
Yeah.
So, thank you.
Thank you all. Rick,
Yes.
go on, join us
Okay.
and just go through where we are at the moment, because I think we've made some changes to the bill.
Yeah, so how do you want?
For Ancestry, we've made a change that accommodated Ancestry.com, and I think Keisha's concerned also. So we've got a couple changes, I believe, that are in front of us. I think we all have a copy of it.
But
So, Rick Sagel with the Office of Legislative Counsel.
And if you have anything to add in the conversation that we obviously have, you have been living with this bill longer than any of us.
So I think a lot of this is policy, and politics, you know, what you all want to do. Nothing that was said was inherently correct, that the update for the committee. New Mexico does have a PRA. The bill is not a word for word of what this bill is. They have their own Genetic Information Privacy Act. It's not specific to direct consumer genetic testing companies. It's actually a much broader genetic information privacy bill. So, New Mexico has a limited with a PRA. That's,
And they've had it for how long?
I didn't see that.
Okay.
I just did Illinois from Mexico
And then Wyoming has the,
with a cure period.
with the cure period, right? So, yeah, obviously Vermont would be an outlier if you included the PRA, policy choice. So, but I do have, a proposed, instance of amendments which address the biometric data, issue. There, was some discussion online and offline about there's a line in the bill. And you want me to share my screen after that comes here?
Sure.
Okay. If you look at the underlying bill as passed by the House, I've requested sharing. There we go. Thank you. Let's see where. Okay. The underlying bill on page 12. Because that's passed by the House. There was language in here.
We have.
Yep. About biometric data. So subdivision 2 at the very top. And this, by the way, the lead-in language is data security and access. That's the category of subsection, data security and access. So number 2, genetic data and biological samples of consumers shall not be stored within the territorial boundaries of any country currently sanctioned in any way by the U.S. Office of Foreign Assets Control or designated as a foreign adversary under federal law. So then number 3, genetic data or biometric data of consumers shall only be transferred or stored outside the U.S. with the express consent of the consumer. The more I looked at this, I started to understand that this is maybe not within the scope of the bill. This would open-
Biometric data is beyond.
and it's not necessarily applicable just to direct-to-consumer testing companies. I mean,
Right.
at the end of the day, the enforcement is limited to service providers and direct-to-consumer testing companies, but I think it's confusing to all of a sudden add in the phrase biometric data. My guess is that when developing this bill, using various languages found in other states, this was maybe not intended as the specific language. So the proposed amendment, which you have, changes, it deletes. I kind of restructured this a little bit. Number 2 stays the same on the amendment. Number 3 is changed to where we say genetic data and biological samples instead of biometric data. So because the bill refers to those 2 things and not to biometric data. Biometric data is only used because publicly available information includes the term does not include biometric data. So the bill otherwise does not regulate biometric data. So that's a proposed amendment. I think it avoids any like
And addresses patient concern.
I don't know. She'll have to speak to that. But I think it addresses my concern that this bill was not intended to cover this other thing that could leave in some entities you don't want to leave in.
And thanks to Ancestry, I think that was also pointed out by you.
This was a team effort of finding something that, you know, and again, I think at this point, everything else is policy and talking about the cure period, talking about PRA, you know, it's up to you all how you want to settle this.
So we're getting close to the end of the session. We got 3 weeks left. I'll just say I'm not persuaded that a PRA is the right thing. I don't know what problem it's going to solve, and I don't like Vermont getting out there, and I don't want to just help trial attorneys be able to file lawsuits. But if this moves forward without my vote, that's completely fine too. But I'll just say I'm not there. So if we're looking at an amendment to move this out, if you have the 3+ votes with PRA, great. But otherwise, I'd want to see an amendment on that front. And
So-
I'd also open to a cure period that would also put in the middle. That's where I am.
Okay, so if we did a PRA, you would only be willing to do it with a cure period.
I'd want to see what that cure period is compared to Wyoming and dig deeper into it. But that's
Okay.
why, but I
So-
don't need to be unanimous.
I don't think it's for lawyers. I mean, I think a PRA is actually for our constituents. So because this is unlike some of our other data privacy bills and data bills, this is really about the individual and the consumer and the company. And this to me is empowering for an individual, not for a company or anybody else. So this is, and not for lawyers. This is really so that if somebody is really wrong, not emotional damage, and in some way that their genetic data has been used ill,
I trust
this gives an opportunity for
the
that.
Attorney General's office to determine and assess if that truly is a big harm. And
So-
they would bring that action forward. Otherwise, I just think it'd be interpretation of harm that is very hard to liquidate on. That's right. But
Got
yeah, if you guys got the votes, go, just move it.
I'm not enthusiastic, as I mentioned before.
So gentlemen, where are we before we switch gears and move to another? Where are you on your thoughts on this bill? So I'm fine with the bill as it has come to us with that change, because I believe that addresses, I mean, this one change addresses the concern I believe I heard from Keisha, and we heard from Ancestry.com. So I'm happy with the bill as changed by this amendment. But as you all know, I'm a big supporter of PRAs, and I know a number of you have more reservations, but David.
Still listening, but are you
Okay. I
referring
appreciate-
first to
you know
this
what?
amendment?
I just want to say, I appreciate Peter listening. That's right. I appreciate all of us listening and really trying to, hear it all. Because I think we're all trying to do that. We're all trying to and we haven't had as much time with this bill as we've had with other bills. So that's part of why we're dealing with it today. Is
We're
to,
just coming down to the end, so I'm not trying to
Yeah.
put like cards close to the chest. I'm just trying to
No,
give
and
an idea of
I
where
appreciate
am
that.
so that we can
And I
get
think
out of here on time.
thinking all along, at the beginning of the bill, on top and proper rights of action. So I think they tend to encourage litigation. I understand the arguments that I heard from folks about it, and how it's been used in Vermont, but day after tomorrow, the new law firm will start with this is private rights of action if the law is so runs by two. Orangestown, that's pretty small.
Yeah.
That was painful.
That's why I love. Evacuate the building and
and then, well,